All right. Record should reflect we've had a lengthy bench conference in this matter. And Mr. Brown brought forth the point that this case, in some form and or another, was previously adjudicated at preliminary examination in June, and the case was dismissed.
This opening immediately throws us into the deep end of courtroom chaos. Judge Simpson is making it crystal clear. This isn't just a routine matter. We're dealing with a case that has already been dismissed once, then somehow resurrected under the flimsy claim of new evidence. And what is this so-called new evidence? A police body cam video that existed from day one. This is huge because in law, reauthorizing a case requires actual new material, something not previously available. By calling out that the evidence was already in the state's possession, Judge Simpson is setting the stage for a scathing takedown of prosecutorial missteps.
When I say the case, I guess I'm talking about the factual circumstances of this case, because it was then reauthorized against this individual. This case, then this one then coming. What happened on the reauthorization is that a count was added. We had, I don't know how many attorneys up here trying to clarify what was added and the basis for it. As I'm to understand, so that the record is clear, the basis for the reauthorization was new evidence. That might be a basis to reauthorize a case if it were truly new evidence. Upon questioning by the court, the prosecutor that reauthorized it indicated that the new evidence was the body cam footage from the police agency, which existed at the time of the original case. And that I don't know under what definition of new that even falls, but that the case was previously dismissed because there was conflicting testimony as to whether or not the backpack was blue or whether it was black.
Here Jones pivots to mental health as an explanation. Trauma, therapy, demons, all terms defendants often raise late in the game. The problem is timing. Simpson immediately calls out the inconsistency with the pre-sentence report, which documented no mental health history. That contradiction makes the therapy claim sound like a desperate card pulled from the deck at the last second. Viewers should note, courts take mental health seriously when documented early, with evidence. Dropping it only when sentencing looms often backfires. The judge's response, "The last person you want to lie to is me," makes it crystal clear. This isn't compassion territory anymore. It's about honesty versus manipulation.
They went back to look at evidence which was already in the possession of the, or available, I should say, to the people, of the color of that backpack, determined the color, and then brought this new case against this defendant. The reality is, don't care how you dice it, slice it, cut it, that's not new evidence. That's just evidence that wasn't looked at by the people at the time of the original case. And quite frankly, I probably would have had a lot more to say, but we got a lot here today. But I will tell you that I told the prosecutor, and I'll make it very clear, that is not new evidence. It shouldn't have, this case should never have been reauthorized, because it's not even really a reauthorization, because it's really a nothing. This defendant should not have been before this court on this charge, had to go through that entire process. This witness should not have had to be here. They should have just admitted to their mistake from the very beginning, just called it and said, we blew it.
The judge lands the knockout punch. By declaring that the defendant should never have been dragged back, Judge Simpson highlights the emotional and financial toll of such missteps. Think about the ripple effects. A witness forced to testify again, a defendant put through the stress of trial prep, and taxpayers footing the bill for a case that shouldn't exist. And then the phrase "with prejudice" that's key. It means the case is permanently dismissed. No second chances for the prosecution. This is as final as it gets. If you were in the defendant's shoes, how would you feel, relieved or furious that it took this long for justice to prevail?
They've blown it. This case is previously dismissed. This one, albeit a reauthorization, this court is ordering that it is dismissed, and these charges are dismissed against this defendant given what's happened with prejudice. Sir, you may step down. Thank you. Case of the people of the state of Michigan versus Jeremy Shue.
Al Chmielewski for the people.
Good morning, Your Honor. Jay Kill on behalf of Jeremy Shue. Jeremy, would you state your name for the record?
Jeremy Shue.
Thank you.
Your Honor, today we adjourned one of the R&O charges against Mr. Shue because we didn't have a medical. I'm not sure we still don't have the medical, but that being said, in the interim, Mr. Shue wrote a 2-page letter to me basically saying that I should be disbarred. He refused to see me at the jail. So obviously there's been a breakdown in attorney-client privilege. He has every right to be represented by an attorney. He obviously doesn't want me. I'll leave it in the court's discretion. I'm asking to be withdrawn.
That speaks, sir.
Go ahead, Jeremy.
Your Honor, Mr. Kilwaw was substituted by Ms. Freshour due to Mr. Kilwaw.
What do you mean substituted by?
Judge, there were 4 traffic offenses I was also pointed on with Judge Freshour. And in my conversations with Mr. Shue, I filed a motion for Judge Freshour to recuse herself, which apparently didn't sit well with Mr. Shue.
Again, I'm sorry.
No, I just had to get clear what you were telling me because I didn't know.
I was trying to tell you, but Mr. Kilwaw's cut in.
Well, no, I asked him, Jeremy, to explain it to me. So,
No, what I was gonna tell Your Honor was Judge Freshour substituted Mr. Kilwaw for Mr. Bob Elman. However, due to Mr. Kilwaw not coming to see me, I still haven't got no medical records from the prosecutor, which that's a violation.
well, hold on, Jeremy. You're jumping ahead because what I understand is they don't have them. Yeah, it's not like, hold on. Got to quit being so suspicious, right? If the prosecutor had given them to Mr. Kilwaw, there's not a doubt in my mind he would have gotten them to you because that's what we've been waiting. So you're jumping ahead. You're getting suspicious like somebody's trying to withhold something or denying you your rights. If it's not there, that may work to your advantage. But, well, now you understand, but you were about to go off on something. So, yes, you were. Go ahead.
Notice how Judge Simpson cuts in, trying to keep Jeremy Shue on track. This is courtroom management at its finest. Shue is spinning off into accusations, conspiracies, and backstory, while the judge reins him in. Slow down, explain it to me. This is a subtle yet powerful reminder. Courtrooms thrive on clarity, not chaos. When defendants derail, judges act like anchors, pulling the narrative back to focus. But here's the drama. Shue insists his lawyer filed motions against his wishes, even accusing him of perjury. The stakes: if true, it's malpractice; if false, it's paranoia. Question for you: when a defendant distrusts their lawyer this much, can justice still be served, or is the case already doomed?
Mr. Kilwaw filed a motion without my knowledge or without my input to Judge Freshour that was perjured, saying that I filed legal action against Your Honor. Ms. Freshour didn't really care for that when I explained to her that Mr. Kilwaw, I have documents.
Well, hold on. You got to slow down because I'm not there. So you got to explain it to me. Okay. So Mr. Kilwaw files a motion. What was it? A motion to recuse?
Correct.
And saying that you had filed something against Judge Freshour, like a grievance or something?
No, it was legal action against Judge. As of yet, I haven't pursued the last domestic violence that was falsely charged as of today. There's also other great.
Well, hold on, just hold it. So you're saying that Mr. Kilwaw made some statement that was false in that motion? Okay. And the statement you're saying is what?
that I filed legal action against, Judge Freshour, which as of today, I have not.
Okay, but you were anticipating that you might do that.
Yes, I am.
Okay, okay.
Pursue the malicious prosecution.
Okay, all right, I got you. Okay, so let me just stop you there, and I know you got more to tell me. If Mr. Killawald knew that you were contemplating it, then him making that statement would be a proper statement to make to the court. Okay? So again, I think you're jumping ahead saying he's filing something that's perjurious or whatever, but he would, and in fact would be protecting your right by doing that. Okay? All right. Go ahead with your next part of your conspiracy.
Due to, as of to date, we haven't had no discovery in either of these matters. As of to date, we haven't got the police report, or not the police report, but the camera. What other Scott was there, we're entitled to have the camera.
And Jeremy, you're going to start quoting law to me now.
I'm sorry, sir. I'm
Jeremy, how long have we been dealing with each other?
long time, sir.
Yeah. You think I know the law?
Yes, I.
Okay, but go ahead. I'll let you talk.
The other thing is, in the domestic violence allegation that was falsely charged and rightfully dismissed, it was prosecutor Jessica Blanche made a comment stating that I would not be charged with these R&Os had I completed a treatment program in that domestic violence case. The domestic violence was ultimately dismissed. The probation violations was ultimately dismissed. So that threat for vindictive prosecution raises another issue, which we need to transfer from that domestic to show that it's blanket threat. If Mr. Killawald would have bothered.
Well, but hold it, Jeremy.
I understand I'm getting ahead of myself.
Yeah, you are. So you're saying that the prosecutor made a statement that if you completed some type of batter's intervention or domestic violence program.
It was a dual diagnosis program in Saginaw, which due to my
Yeah.
wheelchair and all that stuff, I wasn't allowed to attend that program. And Judge Conlon ultimately dismissed the probation violations.
Okay.
Due to the violation of the program itself.
All right.
As of now, I sat in jail. I was out there doing what I needed to do. I was threatened by the prosecutor in the falsely charged domestic, where I did 4 months for misdemeanor. The domestic was dismissed. The witness intimidation was brought up, ultimately dismissed.
Okay, Jeremy, I'm going to stop you again. All of that may have happened. I'm not understanding what that has to do with what's before me.
I understand, sir.
Here's a masterclass in judicial patience. Jeremy is connecting dots between dismissed domestic violence charges, probation violations, and alleged threats from prosecutors. But Judge Simpson isn't buying it. He acknowledges the claims yet cuts to the core. What does this have to do with this case? That's laser focus. Legal proceedings can't be derailed by grievances, however dramatic they sound. Still, Shu's rant raises a real issue: vindictive prosecution. If prosecutors pile on charges to punish a defendant, that's unconstitutional. The judge doesn't say it outright, but by narrowing the scope, he's protecting the case's integrity.
Plays into the vindictive prosecution of this case that we're setting here. And now, in the police report, they state that there was medical records. However, one of the reasons Mr. Kilwall, our communications had broke down, is because he gave me, with the prosecution knowledge and coming from the prosecution office, gave him, obviously, he gave me personal information, Sergeant Victim, of the last time he was here. When I brought it up to Mr. Kilwall, that he gave me the address, the phone number, social security number, the driver's license number, and everything. He told me to hang on to it. He basically blew me off.
Judge, I gotta stop right here. There's no way I told this gentleman to hang on to that stuff, okay? And I've been listening to him patiently. I've tried to see him a couple times. He refused to see me. The one time he did, it lasted 30 seconds. He turned his wheelchair around, said, "You're fired." So he can talk all he wants.
Anyways, he gave me documentation. I had to bring that documentation up to a sergeant at the jail on camera and give him that documentation because I felt that I was being set up for another witness intimidation case, which the officers involved in these matters, I have no hostility towards. I don't have no ill will towards. I don't mean them or their families any harm. I'm not a violent person. I was outside of jail doing what I needed to do. I had that information. It was like, how did this information get from the prosecutor, Mr. Kilowog, to me?
Okay.
This is the jaw dropper. Shu claims his attorney handed him personal information about a victim, social security numbers, driver's license, the works. That's a legal and ethical bombshell. If true, it's an outrageous breach of privacy. But here's the twist. Judge Simpson doesn't believe it. He cuts in, essentially saying there's no way that happened. The tension here is electric. On one side, a defendant in meltdown mode. On the other, a judge fiercely protecting courtroom officers' reputations. This clash isn't just about facts, it's about credibility. Whose word would you trust in this moment, the frustrated, defensive defendant or the judge's unshakable faith in a veteran attorney?
All right. So Jeremy, hang on a second. Let me assume for the sake of argument that what you're saying is true. Okay? Let's say the prosecutor turned this over to Mr. Kilowog. Mr. Kilowog gives it to you. Let's just, for the sake of argument, I don't know that it happened that way. I don't think necessarily it would. You say something to Mr. Kilowog. Mr. Kilowog goes, well, just hang on. Okay? That's what you're telling me. So the conclusion, hold on, the conclusion you jump to is that Mr. Kilowog is some part of some conspiracy to do that to you, right?
Yes,
Okay, Mr. Jeremy. I'm going to tell you you're wrong. Absolutely wrong. I've known Mr. Kilowog 25, 30 years. He's a good attorney. He's a great attorney if you just listen to him. All right? There is no way ever that he would ever do something, the prosecutor, let alone anybody else, that is going to forsake his client. It would never happen. And that's why Jeremy, I'm telling you, the conclusion that you're coming to is the wrong conclusion. Because with that man, that will never happen.
Understand but from the actions that I'm.
Hold on, Jeremy, but you're jumping to a lot of conclusions about a lot of stuff. All right? And I'm just telling you, and Jeremy, as long as we've been dealing with each other, I tell it to you straight. If I thought Mr. Kilowog might do something like that, I'd say, okay, well, whatever. But I'm telling you, he'd never do that. Ever. It does. Okay, but Jeremy, what if you say something to him, he misunderstands what you're telling him and says, just hold on to it.
That could have been possible.
Okay, then Jeremy, I'm saying, if that's possible, quit jumping to the negative. I'm telling you, jumping to the negative with this man here is just wrong.
At this point, Judge Simpson turns almost parental. He scolds Shu for assuming the worst in every interaction, reminding him, quit jumping to the negative. This is fascinating courtroom theater, because it shifts from legal sparring to almost life coaching. The judge knows Jeremy has a pattern, misinterpreting actions as conspiracies, and he's calling it out directly. For viewers, this moment reveals the human side of court. It's not just statutes and rulings, it's personalities, egos and conflicts all colliding in real time. The energy is tense yet oddly intimate. like watching a teacher discipline a stubborn student. Would you say Judge Simpson is being too harsh, or is this tough love exactly what Shu needs?
So, Jeremy, what do you want me to do? Because my understanding is we were waiting on medical on this case. Right. And so maybe, Jeremy, if you talk to your attorney, maybe there's something else that's going to happen.
I'm willing to use like to hold off on this. I'm willing to see. It hasn't came up.
Okay. Jeremy.
Sorry.
Jeremy, maybe he hasn't come to see you because you don't act right. Jeremy, don't even try with me because sometimes, even though you're on my docket, I don't want to see you. Okay? So now, Jeremy, I'll ask you this. Do you want me to hold the motion that Mr. Kilowald has raised in abeyance, send you back, give you an opportunity to talk with him, and talk with him?
Yes, sir. I will.
Okay. Jeremy, when I say talk to him, what do you think I mean by that?
No talk.
Wow. Well, you actually learned something today. All right? If you if you don't understand something, don't jump to the negative like you did with everything you just told me here. Just if you don't understand something, ask the man. Just okay. And you don't listen to that either, do you? No, you don't. Don't even. You started trying to talk, and you know what the answer to that is. You don't listen. So here's what I'm going to do. I'm going to pass this matter. They're going to take you back. They're going to get you out. I'm going to hold Mr. Kilowald's motion in abeyance. You're going to talk to Mr. Kilowald. Jeremy, you're going to talk to Mr. Kilowald. You're going to listen to him. Jeremy, if I believe this man would ever lead you astray, I'd get you a new attorney. He's not going to lead you astray. He's going to give you the best advice that he can, and he will fight for you. Got it? All right, we'll call you back up in a bit. Court recalls the case, people of the state of Michigan versus Jeremy Shu.
Good morning, I'm Rob Jenkins on behalf of Mr. Shu. Jeremy, would you state your name for the record? Judge, Mr. Shu, he and I have had a nice conversation.
Was shocked.
Well, he's promised to let me see him at the jail. There's been an offer made on partial offer made. We have to confirm if there's going to be a second or a complete offer made. That all being said, can we adjourn this till the 17th?
That good with you?
Yeah, yes, sir. I'm playing. You keep playing with me.
I'm playing with you. What do you mean I'm playing with you?
No, I understand. I'm being sarcastic.
Okay.
That's great.
And he's going to let me see him at the jail, and we're going to talk about it, and hopefully we'll have this matter resolved when we come on the 17th.
Sure.
It's amazing when you just take time and talk with somebody. I tell you, he's not going to let you down.
Don't promise too much, Judge.
No, you need to let him down. I know if something bad happens, it's not because he didn't try.
His name ain't Brian Linson or Jeffrey Pfeiffer.
Well, and maybe that's good.
Okay, so
17 in person.
okay.
Jeremy, we'll see you then. All right, take care.
Your wisdom is correct, at least for today.
Excuse me?
Thank you very much.
My wisdom is long lasting.
I hope so. I may be calling you from the jail. All right, thank you.
Take care, Mr. Kilowald.
And that's the wrap. Judge Simpson, with his trademark dry wit, closes the session by joking about his long-lasting wisdom. But But behind the humor is a courtroom saga packed with tension, reauthorized cases dismissed with prejudice, a defendant publicly feuding with his lawyer, accusations of conspiracies, and a judge holding it all together with sharp authority. What do we take away? Judges aren't just referees of legal arguments, they're guardians of credibility, fairness, and order. Simpson's refusal to let paranoia derail justice shows why courtroom oversight matters. Cases like this highlight the razor-thin line between protecting defendants' rights and keeping proceedings from descending into chaos. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
And now, the pivotal moment. Officers say he refused to step away. Pay attention, because whether that counts as obstruction becomes the heart of the fight.